ready? Start. All these original petitions are filed challenging the orders of assessment under the Kerala Building Tax Act 1975. The buildings in question, though integral ones, portion of which are alleged to belong to various persons separately, and they claimed separate assessment in their names. Their claim is based upon the definition of building in Section 2 of the Act as well as explanation 2 to the above subsection. It is also submitted that tax is payable by the owner, and if a separate ownership in separate flat, apartment or separate portions is proved, there should be a separate assessment based upon the definition of owner as well as the liability to pay tax. These buildings are also commercial buildings, and a contention was raised by the revenue that in any event explanation to section 2 of the act is not applicable to commercial buildings. Considering the various contention, the learned single judge referred these matters to the division bench. Para. An important question relating to the interpretation of the Kerala Building Tax Act 1975 arises for consideration in these cases. The buildings in question, though integral ones, are alleged to belong to various persons in portion, and these persons claimed separate assessments under the Act over the portion alleged to belong to them. There are cases where a single building has been put up on land belonging in co ownership to various persons, and the portions are different floors of the building and are claimed as belonging to each under some arrangement between them. Cases where the building is claimed as belonging even to persons who do not have any ownership in the land, who claim to have contributed to the construction and thereby claim an identified portion of the building as their own. There is also a case where the building is alleged to have been constructed on land lying contiguous of various owners with the respective portions separated by common walls, but a common hall is put in the upstairs. All these raise complicated question of law, particularly the last one mentioned as to how the assessment of the entire building is to be completed. Incidentally, in some of these cases, the question of capital value is also involved. Para. In imposing pecuniary burden on the SSC, the provisions of the Act should be strictly construed. In taxing, one has to look solely on what is normally said. There is no equity about a tax, and there is no presumption as to tax. In construing fiscal and in determining the liability of a subject to tax, one must have regard to the strict letter of the law and not merely to the spirit of the statute or the substance of the law. If the revenue satisfied the court that the case falls strictly within the provisions of the law, though equity and taxation are often strangers, attempts should be made that these do not remain always so, and if a construction results in equity rather than injustice. Stop.